discuss the facts of your case.
Anh đừng có nói về vấn đề. Thành hôm nay là mình đừng có bàn về cái tình trạng cái kê của anh nha.
I'm now going to tell you of certain rights that you have.
Và bây giờ tôi sẽ kể cho anh nghe những cái quyền lợi, những cái quyền hạn mà anh được anh có.
You have the right to the presumption of innocence.
Nhất là không có ai mà hiện tại bây giờ là không có ai làm buộc tội anh hết. Anh hiện tại là vô tội.
You have the right to indictment by a grand jury for most felonies or by accusation for misdemeanors.
Rồi anh có thể là đi ra cái và cái tội của anh đó là vấn đề là được những cái quyền để mà anh đi ra xét xử.
You have the right to a speedy and public trial by jury.
Anh được quyền là cái kê của anh được quyền là đi ra xét xử nhanh chóng bằng bồi thẩm đoàn.
You have the right to see, hear, and question witnesses who are called to testify against you.
Rồi khi mà đi ra chống án, anh được quyền là hỏi những cái nhân chứng ở ngoài tòa.
You have the right to compel the attendance of witnesses to testify on your behalf.
Rồi khi mà ra đó, anh được quyền yêu cầu những cái nhân chứng ra để mà bào chữa cho anh. Người ta phải đi ra tòa, anh được cái quyền đó.
You have the right to testify on your own behalf or offer evidence in your own defense.
Rồi khi mà đi ra đó, anh có thể là từ ra để làm nhân chứng mà bào chữa cho chính bản thân anh.
You have the right to have an attorney represent you.
Rồi anh có quyền là yêu cầu một luật sư để mà tư vấn và để mà bào chữa cho anh.
If you cannot afford an attorney, one can be appointed to represent you if you qualify.
Nếu mà trường hợp mà mình không có khả năng để mướn luật sư, nhưng mà tòa sẽ cung ứng cho anh một luật sư công để mà giúp đỡ anh để bào chữa cho anh.
In this case, you've been charged with aggravated assault and I've set a bond at $10,000.
How much, John? Can you say that again?
$10,000.
Thì trong cái trường hợp của anh đó là anh bị công tố về cái tội hành hung bạo động, thì cái số tiền mà để mà chuộc anh đi ra khỏi tòa để mà tài ngoại hầu tra đó là tới 10.000 đồng.
There will be a stay away provision on the bond to stay away from your wife, a Mrs. Ty Tran.
Rồi một cái nữa là khi mà anh mà tại ngoại hầu tra đó, anh không được ở gần vợ anh là bà Thái Tran.
Do you understand the stay away provision?
Anh có hiểu vấn đề đó không? Tức là anh không được gần vợ anh khi mà anh mà đi tại ngoại hầu tra. Anh hiểu không?
Okay. You're going to have a preliminary hearing date set for October 27th.
Rồi cái ngày mà đi ra tòa tới của anh đó là ngày là 27 tây tháng 10 năm 20.
At 8:30 in the morning in courtroom 201.
8:30 ở cái courtroom 201.
However, that date will get waived upon your bonding out and you'll get a new court date in the mail.
Còn nếu mà trường hợp mà anh mà đi ra tại ngoài hầu tra thì có thể là có một cái phiên tòa khác, nhưng mà nếu trường hợp đó xảy ra thì người ta sẽ làm một cái ngày khác, người ta sẽ gửi thơ tới cho anh biết một cái phiên tòa khác, người ta sẽ báo cho anh biết.
Would you like for me to see if you qualify for the appointment of a lawyer?
Anh có muốn là tôi xem xét coi anh có tiêu chuẩn để mà được luật sư công không?
Are you currently working, Mr. Thong?
Anh Thông bây giờ anh có đi làm không vậy?
Đang đi làm.
Yes, I am working.
About how much do you make per hour or per month?
Mấy đồng một giờ, hoặc là một tháng anh làm được bao nhiêu tiền?
Đang làm họ trả 16 đồng mấy chục sen, nhưng mà tới tháng 9 này là họ giảm xuống là còn 13 đồng 50 sen.
Current right now, they pay me $16 an hour, but after September they will reduce to $13, Your Honor.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you.
Ok, thì chừng cái lương đó thì anh có luật sư công thì tôi sẽ cử cho một luật sư công để giúp anh nha.
Anh cho tôi hỏi này một xíu.
Can I ask you a question?
Yes, sir.
Giờ hỏi đi.
Thì hiện tại giờ tôi bị giam giữ luôn hay sao, khi nào tôi được ra?
So in the meantime, am I stay in the jail or can I leave the jail?
You will be allowed to post a bond today.
Nếu mà anh có tiền 10.000 đồng anh đưa cho tòa để tòa giữ thì anh được ra.
That's going to happen in a couple of hours because the jail cannot process the paperwork until I complete my paperwork and send it to the jail.
Thì khoảng 2 tiếng đồng hồ sau đó, khi mà tôi làm việc xong rồi tôi gửi cái giấy tờ qua bên tù thì tù thấy cái đó rồi anh có thể bỏ cái tiền vô hoặc là nhờ bạn đóng tiền thì anh được ra nha.
10.000 hả?
10,000, is that right, Your Honor?
Yes, sir.
Dạ, đúng rồi.
Nếu trường hợp không có số tiền đó là họ giữ tôi trong này luôn hả?
If I don't have 10,000, so I have to stay in here?
No, sir. And that was a great question. You can use a bonding company that generally charges a percentage of about 10 to 12% of the bond.
Trường hợp anh không có đủ 10.000 thì anh có thể dùng một cái bonding company đó. Thì khi mà người ta sẽ bỏ 10.000 ra cho anh thì người ta sẽ chạc anh khoảng từ 10% tới 12%, thì có thể là 1.000 tới 1.200 thôi.
The fee that they would charge is non-refundable to you.
Cái tiền mà người ta chạc anh đó thì là nó sẽ không có trả lại cho anh đâu, tại là cái đó là cái tiền phí.
If you have property that has at least a value 3 times or equity 3 times the bond amount, you can use your property to secure your bond.
Nếu mà trường hợp mà anh có bất động sản nào á, mà có thể từ 30.000 trở lên đó, thì anh có thể thế chấp cái bất động sản đó, thì anh cũng được đi ra bằng cách đó.
In that case, the sheriff would place a lien on your property until your case is over, and then they would remove the lien. Rồi
nếu mà trường hợp vậy đó, anh có cái nhà anh thế vô thì sở cảnh sát người ta sẽ để một cái lien, tức là người ta để một cái nợ ở trong cái nhà của anh cho tới khi mà cái kê của anh xong rồi đó, người ta sẽ gỡ bỏ cái lien đó.
Bây giờ tôi thì không có người thân, bây giờ tôi có vợ, hiện tại tôi với vợ tôi vẫn hòa thuận với nhau rồi, không việc gì. Bây giờ tôi cho cái số điện thoại của vợ tôi cho anh, có thể tí xíu hơi xong việc đó, anh có thể gọi cho vợ tôi, anh nói vấn đề này với vợ tôi được không anh giúp tôi chuyện đó.
Mr. Interpreter, right now me and my wife reconcile. So we're not fighting anymore. Can I give you my wife phone number and then you can call my wife so my wife can help me?
I can't get involved in that situation. Based upon what you've told me, your wife can contact the district attorney's office to let them know that she's not afraid of you and she wants the stay away provision to be lifted.
Cái trường hợp này đó, tôi không có thể nào mà giúp anh được, nhưng mà anh có thể cho vợ anh cái số điện thoại của cái người luật sư. Cái người luật sư mà tôi bổ nhiệm cho anh thì nói vợ anh gọi cái người luật sư đó, nói với cái người luật sư đó là vợ anh không có còn sợ anh nữa, thì cái người luật sư đó sẽ giúp anh.
Thì bây giờ tôi ở trong nhà tù, tôi đâu có gọi được.
I mean, in jail, I don't have phone to call them, Your Honor.
So, Mr. Thong, I can't get into the middle of the dispute between you and your wife, that's something that the two of you are going to have to work through?
Tôi chỉ là chánh án ở cái đây thôi, tôi không có thể nào mà dính líu vô cái sự mà giữa anh với lại vợ anh được. Cái đó là giữa anh với vợ anh sắp xếp với nhau nha, tôi không làm được cái điều đó đâu.
All I can tell you is the process that's involved in having the stay away provision lifted.
Tôi chỉ là bổn phận của tôi chỉ là báo cho anh biết là anh là cái luật là anh đã làm như vậy rồi thì là anh phải không có được ở gần vợ anh thôi. Nhiệm vụ tôi chỉ có tới đó thôi, tôi không làm gì được hết cho anh đâu.
Giờ hiện tại là tôi đang bị trong này đó, rồi khi nào nếu trong trường hợp nó chưa có số tiền đó, chưa có ai làm được số tiền đó bỏ vô thì tôi sẽ ở trong này bao lâu?
So if I couldn't come up with the bond money, then how long do I have to stay in the jail?
I would encourage you to contact the bonding companies because they will work with you and even setting up a payment plan to help you get out of jail.
Tôi khuyên anh nên liên lạc với lại cái bonding company đó, cái company đó, thì người ta sẽ tới, người ta sẽ liên lạc với anh, người ta sẽ giúp anh. Rồi nếu anh không có cái 10.000 đó, người ta cũng sẽ cho anh trả góp.
Nhưng mà bây giờ tôi khổ cái là tôi đang ở trong tù, tôi không thể liên lạc được với vợ tôi.
But the only problem, I'm in jail. I couldn't contact with my wife, Your Honor.
So, Mr. Thong, this is where it becomes a situation where, based upon the allegations of your conduct, that has placed you where you are right now.
Cái trường hợp của anh đó là vì những cái việc mà anh làm đối với vợ anh, thành thử là anh mới rơi vô cái tình trạng này.
I can't go outside of what is accepted as to my duties.
Cái nhiệm vụ của tôi, tôi chỉ làm cho tới đây thôi, tôi không có thể làm cái gì khác cho anh được. Anh hiểu không?
Nhưng mà nó khổ cái giờ tôi không liên lạc với vợ tôi giờ với tôi nó cũng hòa thuận rồi, nó không có việc gì xảy ra, nhưng mà bây giờ hiện tại tôi ở trong tù á, tôi không thể liên lạc được với vợ tôi.
The only dilemma is now me and my wife is working out, Your Honor, but I'm in jail. I couldn't contact my wife.
Do you have any other relatives that you can get in contact?
Ngoài ra anh có người thân nhân nào khác không?
Tôi chỉ có vợ tôi là thân thôi, tôi với vợ tôi không còn việc gì nữa, vợ tôi nó hòa thuận lại rồi.
Yeah, the only thing is my wife. All I have is my wife, and we have working out now.
I'm going to ask the deputies to give you, there's a slip of paper that I've seen before where they have the names of the bonding companies. I'm going to ask the deputies if they would get a slip and give it to you so that you can contact the bonding companies.
Ok, thì thôi bây giờ tôi chỉ làm cái này được thôi nha. Cuối cùng là tôi sẽ nói với lại deputy ở trong đó, đưa anh một cái tờ giấy, trong đó có cái tin tức của cái bonding company, có phone number. Rồi khi anh đi vô trong đó, anh dùng cái số điện thoại đó, anh gọi người ta tới giúp anh đi ra. Ok.
And I'm going to encourage you, Mr. Thong, in the future, don't place yourself in this situation.
Và tôi khuyên anh ở trong tương lai nó đừng có làm như vậy nữa, đừng có làm những cái gì đối với anh nữa. thì anh sẽ bị bắt nữa đó.
Tôi biết rồi,
Anh,
tôi biết chuyện đó mà.
I knew that, Your Honor, I knew it.
Okay. Is it Deputy Lee? Were you the person I saw over on the men's side?
Yes, sir.
Would you do me a favor and at some point give Mr. Thong the slip that has the bonding company's names and telephone numbers on them?
Yes, I
Deputy,
can get one of the jail staff to get it to him. I'll know the jail staff keep it. He'll get one.
And Mr. Pham, could you translate that to
Yes, sir.
Mr. Thong?
Tòa mới nói mới Deputy Lee đó, chút xíu thì vô trong đó thì Deputy Lee sẽ đưa cho anh cái tin tức của cái bonding company, cái slip, cái tờ giấy đó, trong đó có cái number, anh gọi người ta giúp anh nha.
Tôi cũng không biết tiếng Anh, tôi gọi sao được anh?
I couldn't talk to them because I couldn't speak English, Your Honor.
And that I understand the problem that causes, Mr. Thung, and I'm not indifferent to it, but you know, the allegations are that you got intoxicated and threatened your wife with a knife.
Nhưng mà anh biết đó, mặc dù á, là cái lúc anh xỉn rồi anh hăm dọa vợ anh bằng con dao. Anh lấy dao á, anh hăm vợ anh.
Tôi chỉ đôi coi với vợ tôi thôi, chừng cãi vã với nhau thôi.
You know, Your Honor, we just quarrel, we just argue, we just.
Dao đó là vợ tôi mang theo trên xe để gọt đồ ăn, mà gọt cái cây ăn.
Yeah, that knife belonged to my wife. She used it so she can peel all food and stuff.
And I understand, and so I've been married 19 years, and the police have never been to my house over argument or dispute between myself and my wife.
Tôi cũng hiểu cái tình trạng của anh, nhưng mà tôi nói cho anh nghe, tôi cũng lập gia đình 19 năm rồi, mà trong vòng 19 năm đó tôi cũng có cãi lộn với vợ tôi, nhưng mà chưa bao giờ mà cảnh sát mà phải gọi đến nhà được.
And that is because these types of problems that you're talking start from a dispute with your spouse that a knife is produced.
Đó, thành thử là khi mà cãi lộn với vợ chồng mà có dao ở đó thì nó là cái chuyện khác rồi.
So to the extent that you were a person that was in the middle of this, you have to accept the problems that have sprung from your behavior.
Đó, thành thử là những cái chuyện mà anh đã gây ra thì bây giờ anh phải chịu hậu quả những cái gì mà anh gây ra.
Bây giờ trường hợp thôi được, bây giờ cái trường hợp này tôi gọi cái này mà tôi không biết tiếng Anh.
I can call the bonding company, but I don't know how to talk to them, Your Honor.
Which I get and I understand. Mr. Thong, you were born in 1961, if I remember correct.
Anh sinh năm 1961 phải không anh Thông?
Đúng.
Yes.
Sir, you're old enough to not have yourself in these positions. You're not a teenager. You're not 20 years old. Anh
lớn rồi, anh 60 mấy tuổi rồi. Anh đâu phải là còn con nít nữa, mà để anh hiểu cái chuyện này mà anh để đặt anh cái tình trạng này, cái hậu quả này là do anh gây ra thôi.
I want to assist you as much as I can, but I've reached the limit of what I believe I'm lawfully able to do.
Tôi muốn giúp đỡ anh nhiều lắm, nhưng mà cái khả năng của tôi về luật pháp chỉ cho phép tôi như thế thôi, thì anh phải tự lo lấy.
Anh không thể liên lạc được với anh, không có quyền điện cho vợ tôi hay.
How about the interpreter? Can interpreter call my wife?
So, Mr. Pham, that's a question for you to answer. I can't order, direct, or request of
Your Honor,
anything of you, and let him know that I'm saying to you that I cannot order, request, or demand for you to call his wife.
tôi là chánh án, tôi không có thể nào yêu cầu thông dịch viên mà làm cái gì khác được. Tôi không có thể nào bắt thông dịch viên để mà làm những cái chuyện riêng tư cho anh được.
Mr. Thong, did I ask you about appointing a lawyer?
Tôi hỏi anh về vấn đề mà cái luật sư của anh rồi phải không?
Luật sư của tôi hả? Tôi chưa có hỏi với luật sư tôi mà.
Yeah, yes, you asked me.
Okay,
about that.
I did appoint a lawyer. At this stage, you're going to have to rely upon your lawyer to assist you.
Ok, tôi đã cử nhiệm một luật sư rồi, mà cái người luật sư đó họ sẽ liên lạc với anh. Khi liên lạc với anh, người luật sư đó sẽ giúp đỡ anh nha.
Luật sư đó vô nhà tù gặp tôi hả?
So the lawyer will go into the jail to talk to me. Is that your honor?
Yes, sir. Today is Friday. I do not know when the lawyer will come, but it will be sometime in the next few days.
Yeah. Luật sư sẽ vô tù để mà thăm anh và nói chuyện với anh, và sẽ giúp đỡ anh nha. Mà hôm nay là thứ Sáu, thì thứ Sáu rồi là có thể là thứ Bảy Chủ nhật người ta nghỉ, có thể là tuần tới người ta vô, người ta gặp anh.
Tuần tới hả?
Your Honor,
Yes, sir.
I've been advised the jail staff will actually take them upstairs to intake, where they have a language line, so you're going to make contact with the boss and they can translate for them that way.
Okay, could you tell Mr. Thong that?
I couldn't hear
the deputy said that there is a language line. They can take him into intake and use a language line where he can be able to communicate with the bonding company.
Yeah, thank you, Your Honor. Anh Thông, người mà cái người mà cảnh sát đó, họ nói anh cứ gọi cái số điện thoại mà người ta đưa cho anh, thì trong cái số điện thoại đó có người Việt Nam giúp anh.
Bây giờ họ dẫn anh ra tôi đi hả?
Yeah, vô người ta đưa cái số điện thoại, cái số điện thoại người ta sẽ cứ gọi cái đó, tại vì người ta nói là có thông dịch viên ở trong cái chỗ đó. Okay.
Bây giờ cảnh sát dẫn tôi đi gọi không?
So can I go to call them now, Your Honor?
It's going to be based upon the jail's ability to do that, and I'm going to leave it in their hands.
Yeah. Bây giờ sau khi anh đi vô tù đó, thì trở lại tù của anh, thì mấy cái người ở trong đó là họ sắp xếp rồi họ cho anh gọi. Okay.
Okay, you're free to go back, Mr. Thong.
Okay, bây giờ anh Thông đi vô đi, xong rồi.
Tôi cảm ơn anh nha.
Yeah, thank you, Your Honor.
Thank you, sir. And thank you, Mr. Pham. You are free to go.
Yeah, thank you.
Okay, Miss Bermudez, let's start with Mr. Ruiz.
Yes, sir.
Mr. Ruiz, sir, can you hear and understand the interpreter?
Señor Ruiz, ¿puede usted escuchar y entender a la intérprete?
Sí.
Yes.
Okay, sir, you've been charged with one count of driving a vehicle without a license and one count for failing to stop at a stop sign.
Señora, usted se le acusa de un cargo de manejar un vehículo sin licencia de conducir válida y de un cargo de no pararse en un pare.
I've set a bond at $1,000 for the driving on suspended or driving with no license charge and a $500 bond for failing to stop at a stop sign.
Y yo le fijé la fianza de $1,000 por manejar un vehículo sin licencia de conducir y $500 por no pararse en el pare.
The process you're going
Ayer-
through right now is your first appearance for the Magistrate Court of Clayton County.
En el proceso que usted está en esos momentos es su comparecencia inicial en el Tribunal de Primera Instancia del Condado de Clayton.
We're not here to conduct a trial of your case.
Nosotros no estamos aquí para tener un juicio en su caso.
We're here to tell you the amount of bond that's being set,
Estamos aquí para decirle cuál es la cantidad de fianza que le hemos
Sí.
otorgado,
to advise you of certain rights,
para decirle cuáles son sus derechos,
to schedule a preliminary hearing. And in your case, the preliminary hearing is going to be set for October 26th at 8:30 in the morning in courtroom 201.
para fijarle una audiencia preliminar, y en el caso suyo, su audiencia preliminar va a estar fija para el día 26 de octubre a las 8:30 de la mañana en la sala 201.
I'm also here to determine whether you require the assistance of a lawyer.
Y estamos acá también para determinar si usted requiere la asistencia de un abogado.
Would you like for me to see if you qualify for the appointment of a lawyer?
¿Quiere usted que yo vea si usted califica para nombrarle un abogado?
No, porque yo ya pagué el bond desde ayer, nomás que supuestamente te lo voy a enseñar. Haz cuenta, lo pagué anoche, bueno, lo pagaron anoche como las 11. Hace rato me dijeron que me faltaba $40 y yo creo que ya los pagaron ahorita.
The thing is that I know because I paid my bond yesterday,
Okay,
and I'm going to show you they paid my bond last night, but the thing is that they just told me that they were missing another $40, but I think that they already paid it.
okay. I would suggest that additional $40 is paid.
Yo les sugiero que paguen los $40 adicionales,
No,
Just
sí,
so you can get out of jail and then you can deal with whether the $40 charge was valid or not later.
para que usted pueda salir de la cárcel, y ya después que usted salga de la cárcel, usted puede lidiar con el hecho de si los $40, el cargo de los $40 era válido o no.
ajá, sí, de eso no hay problema. Ok, pero no saben ahí ustedes si ya los pagaron.
Yes, that's not a problem, but do you know if they already pay it?
I don't, because I don't have access to that information.
Yo no sé porque yo no tengo acceso a esa información.
Ok, pero me imagino que ya los han de haber pagado porque les hablé en la mañana y me dijeron que iban a venir hoy.
Okay, but I imagine that they have already paid because I called them in the morning or this morning.
Okay. To be clear on the lawyer issue, whether I appoint a lawyer or not has nothing to do with your bond.
Solamente para estar claros con el asunto del abogado, el que yo le nombre un abogado o no, no tiene nada que ver con la fianza.
Ok.
Okay.
It's totally your choice. So is it yes or no as to the
Mm.
lawyer?
Y depende enteramente de usted. O sea, que es sí o no. ¿Quiere usted un abogado o no?
No.
No.
Okay. Let me give you an advisement of certain rights. And
Déjeme-
I'm sorry, Ms. Bermudez, go ahead.
I'm sorry, Judge. Déjeme yo informarles cuáles son sus derechos.
And
Ok,
after,
yo pagando los $40 ya puedo salir, ¿no?
But if I pay the $40, then I could be released. Right?
yes, sir.
Ok.
Sí, señor.
Ok.
During this and all other proceedings, you're going to have the following rights.
Durante este y todos los procesos siguientes, usted va a tener los siguientes derechos.
to the presumption of innocence,
A la presunción de inocencia,
to indictment by a grand jury for most felonies or by accusation for misdemeanors,
de ser acusado por el gran jurado para la mayoría de los delitos graves o de que se le formule una acusación para los delitos menores,
to a speedy and public trial by jury,
de tener un juicio público rápido y por jurado,
to see, hear, and question witnesses who are called to testify against you,
de ver, escuchar y contrainterrogar a los testigos que sean citados a testificar en su contra,
to compel the attendance of witnesses to testify on your behalf,
de exigir la asistencia de los testigos para que testifiquen a su favor,
to testify on your own behalf or offer evidence in your own defense,
de testificar a su favor o de presentar pruebas para ser usadas en su defensa,
to have an attorney represent you,
de tener un abogado para que los represente.
and if you cannot afford an attorney, one can be appointed to represent you if you qualify.
Y si usted no pudiera contratarse un abogado, se le podría nombrar uno si usted califica.
But my understanding today is you do not want an attorney appointed, correct?
Y por lo que yo entiendo en el día de hoy es que usted no quiere que le nombre un abogado, ¿correcto?
No, porque nomás estoy peleando por los $40.
No, because I'm only fighting the $40.
Okay. But again, the two have nothing to do with each other.
Pero una vez más, estas dos cosas no tienen una que ver con la otra.
Oh, okay.
Okay.
Okay, any questions, Mr. Ruiz?
¿Alguna pregunta, señor Ruiz?
No, está bien.
No, that's fine.
Okay, sir, you're free to go back.
Okay, señor, puede retirarse.
And just before I let Ms. Bermudez go, let me check for both sides whether we need any other Spanish language interpretation.
No, Your Honor.
Okay. Before we switch over to the ladies' side, we have a Mr. Ford that is being represented by a lawyer, Mr. Willingham. Can we bring Mr. Ford up on the men's side?
And Judge, may I be excused?
Yes, ma'am. Have a great weekend.
Thank you, sir. You too.
Okay. Mr. Ford.
Yes, sir.
Sir, I normally would speak to you directly, but you've taken advantage of the opportunity to hire a lawyer. So I'm going to speak to Mr. Willingham, but I need to caution you that this is not a private line. This is public. So don't say anything you wouldn't want the whole world to know, okay? All right, Mr. Willingham, Mr. Ford is charged with possession of marijuana, more than an ounce. I've set his bond at $7,500, but I'll hear from you, sir, as to anything you want to tell me about your client or the case.
Judge, thank you. And this incident occurred yesterday at the airport, and Mr. Ford and his family were very diligent to retain private counsel in order to help him. This is, I believe, a second lifetime arrest for him. He's gainfully employed in video production. He goes back and forth between here and California, hence the arrest at the airport. But he's gainfully employed. He's 28 years old. He's got a very supportive family. He's got good ties to the community. He resides permanently at 2321 Halyard Way, and that's in Lithonia, Georgia. I'm sorry, it's Stonecrest, Georgia, DeKalb County. He's college educated, and I say all that, Judge, because he's not a flight risk. He's got good ties to the community. He's taking this very, very seriously, and we are going to ask for a slight reduction of the bond to $5,000 so that his family can free up some funds to continue to retain counsel. And that will aid in his defense. I anticipate that he's going to do during the pendency of the case. But we appreciate the court setting the bond in that amount preliminarily. We would ask for a slight reduction given what I believe is a lack of criminal history. His mother has been late last night. I think she's probably watching on YouTube. She's very worried and concerned. And I think Mr. Ford here was flying back for a cousin's funeral. So he has a cousin that passed away recently. And so they're a grieving family. And this just adds a little more stress on their plate. And without getting to the merits of the case, we'd ask for a slight reduction for him to be able to get out and get to that funeral at as little cost as possible and get back to his family. And I appreciate you accommodating me here this morning.
Yeah, normally, of course, you know, less than an ounce of possession of marijuana, less than an ounce is considered a misdemeanor. 14 ounces is 14 times, and the bond is set here in Clayton County at $1,500. So 14 times that would be more than what I set it at. The problem I have is probably get 6 or 7 cases a week at a minimum of people flying from the West Coast into the airport with marijuana in their suitcase. Majority of them are for the trafficking limit is 10 pounds. Majority of them are 35, 40, 60 pounds marijuana. So I'll reduce it to 5,000. I don't believe that is unreasonable. I think he only has one other arrest. The thing that concerns me, honestly, my career has been a defense lawyer for 20 plus years. And right now, the federal government is not interested in these cases, but one day,
right,
they're going to get interested in them. And the way, the manner means, when they get to do it, they're going to do it big, and it's going to be 30, 40 people in an indictment. And all of that is going to mesh together. So I feel, and I'm saying this knowing that Mr. Ford is listening, just for him to know that one day this may come crashing down. And I know I've had a bunch of other lawyers that I've had that I respect, and they're great lawyers and they're representing people with these charges. But I think one day the federal government is going to get involved, and it's going to be a lot more than what he may be looking at from an exposure standpoint. So I'm going to accede to your request. I'm going to set the bond at $5,000. Hold on, Mr. Ford. I'm going to set it at $5,000. I'm going to set a preliminary hearing date for October 27th at 8:30 in the morning, courtroom 201. That date will get waived upon Mr. Ford bonding out. And he will receive a new court date in the mail. So, Mr. Ford, before you speak, remember what I told you in the beginning, okay? There's generally not a lot of things that you can say to help yourself in this situation, but you can say things that hurt yourself. And we shout people down about talking, because at least talk to your lawyer first before you start speaking. So you have the right to ask me whatever question you want to ask. You have a lawyer here, Mr. Willingham. I generally believe it's best to speak to your lawyer about everything in your case before you start talking. So, Mr. Willingham, do you have a concern about whatever it is Mr. Ford raised his hand to discuss?
I do, Judge, and I would advise Mr. Ford not to say anything at this juncture because I don't think it will help in any way. It can only hurt.
So, Mr. Ford, you have two lawyers here, one a judge, one is a lawyer you hired to represent your interests, saying whatever it is you have to say is probably not a good idea. As a judge, I have to say, if you want to say something, you have the right to say something, but it's generally not smart, especially when you have hired a lawyer.
It wasn't a question about the case, but it's fine. I won't ask.
Okay.
It was
Okay.
more about
So,
what you had said to me. I had like questions about what you stated to me, but I'll ask my lawyer.
yes, speak to your lawyer. It is always best to speak to your lawyer first about any legal question before you start speaking to anybody else. Okay? All right, sir. Mr. Willingham, is there anything else? Mr. Willingham?
No, Your Honor. No, Your Honor. Thank you. Can you hear me?
Yes, sir. Mr. Ford, you're free to go back. Mr. Willingham, you're free to go.
Thank you. Have a good day.
You too, sir. It was good, great meeting you.
You too. Thanks.
Okay, let's switch over to the ladies' side. All right, so we're an hour into this already. What I'm going to say to both the men and the ladies, because I hope that you've been listening, paying attention to what I was saying before. So I'm not going to go through the whole thing. I'm just going to tell you that you all have the right to the presumption of innocence. You all have the right to an indictment by a grand jury for most felonies or by accusation for misdemeanors. You all have the right to a speedy and public trial by jury. You all have the right to see, hear, and question witnesses who are called to testify against you. You all have the right to compel the attendance of witnesses to testify on your behalf. Each one of you can testify on your own behalf or offer evidence in your own defense. You all have the right to an attorney. If you can't afford an attorney, one can be appointed to represent you. And lastly, you all have the right, if there's a question in your mind, you can ask that question. I simply ask to let me get through giving you the charges, the bond, and the court dates. And then at the end, I'm going to give everyone the opportunity to ask whatever question they want to ask. So that way we can try to keep this thing moving. Okay? So let's start over on the ladies' side. With Miss Canis, I believe. Ma'am, you're charged with one count of battery, family violence. The bond is going to be set at $5,000. Do you believe you can post that bond?
No.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, ma'am, you do qualify for the appointment of a lawyer. There's going to be a stay away provision on this bond, to stay away from a Tyrone Tony. Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Clark. Right.
Ms. Clark, ma'am, you're charged with one count of false imprisonment and one count of battery. The false imprisonment is a felony offense. There's going to be a $5,000 bond set for the false imprisonment and a $5,000 bond set for the battery, for a total bond of $10,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Lou Cepeda. Do you understand that?
Yes, sir.
Would you like for me to see? It doesn't look like you filled out a form. Did you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Did you fill out a form?
Yes, sir.
Okay, I don't see your form. Let me ask you this question, Ms. Clark. Are you currently working? Oh, sorry, I just passed it. Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
As far as the state provision, you said I would have to, well, I heard you talk to somebody else about it. You said I would have to call the district attorney's office.
Well, the alleged victim, Mr. Cepeda, would have to qualify, call the district attorney's office. The reason we place, primarily the reason we place these stay away provisions on the bond is that most people, these are misdemeanor charges. You're going to get a bond, you're going to bond out. And that's normally the next day. What we don't want is whatever dispute, argument, whatever happened the day before to flare back up when you get out. So we place a stay away provision on the bond. If Mr. Cepeda is not afraid of you, he can contact this attorney's office and let them know. And they will look into it and it'll be their decision. And as a judge, if the parties have agreed to some kind of consent order, I'm not going to get in the middle of it because they've done their due diligence.
Yes, sir.
Okay. And your preliminary hearing date is October 27th at 8:30 in the morning, courtroom 201. That date will get waived if you bond out. Do you have any other questions for me, ma'am?
No, sir.
Okay, you're free to go back. Ms. Johnson?
Johnson. We have Ms. Graves up.
Okay, you said Ms. Graves?
Yes, Your Honor.
Okay.
Ms. Graves.
Okay, Ms. Graves, ma'am, you're charged with 1 count of criminal trespass, 1 count of false imprisonment, and 1 count of battery. There's going to be a $3,000 bond set on the criminal trespass charge, a $5,000 bond set on the false imprisonment, and a $5,000 bond set on battery. So that's going to be a total bond of $13,000. Do you believe you can post that bond?
No, sir.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for October 27th at 8:30 in the morning, courtroom 201, because false imprisonment is a felony charge. I would encourage you to contact the bonding companies. That's their business model, is helping people to get out of jail. So they'll place people on payment plans. They'll do a lot of creative things, but you're going to have to contact them and you're going to have to work that out. Okay.
Okay.
Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Ms. Johnson.
Okay, Ms. Johnson, you're charged with 1 count of theft by taking. This is a misdemeanor offense. The bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, Your Honor.
There's going to be a preliminary hearing date set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
All right, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I would have to pay that full amount to be a bonded out.
No. So you can go through a bonding company. The bonding company generally charges a percentage of the bond, somewhere between 10 and 12%. That is their fee. So in your case, and your bond is going to be a little bit higher because Sheriff's Department is required by law to add fees to every bond. So if it's the $2,000 amount and there's a 10% charge, you would have to pay $200 to get out. Okay, any other questions, ma'am? Okay, you're free to go back.
Ms. Kittle.
Ms. Kilgo, ma'am, you're charged with 1 count of driving under the influence, 1 count of fleeing from a police officer, 1 count of reckless driving, and 1 count of violation of license restriction. And in your case, it appears, and they said you're driving on the wrong class, license class. The bond is going to be set at $2,000 for the driving under the influence, $2,000 for fleeing from the police officer, $1,500 for reckless driving, and $500 for the license restriction. So you're going to have a total bond set at $6,000. Do you believe you can post that bond?
Try.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Ms. Marion, my time.
Ma'am, you're charged with 1 count of felony shoplifting and 1 count of criminal trespass. Bond is going to be set at $5,000 on the felony shoplifting charge and $3,000 on the criminal trespass. So that's going to be a total bond of $8,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for October 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back.
Ms. Marion Tequila.
Ma'am, you've also been charged with 1 count of felony shoplifting. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is also going to be set for October 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your making bond. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, do you, like, if this at burn the company in another county, would I be able to burn out?
Would you restate that question
Would I be
again?
able to use another bonding company in another county?
The bonding companies have to be authorized in each county. Some bonding companies have offices in multiple counties. I think Free at Last Bonding has bonding companies all over the state. So it's dependent upon what bonding company. If the bonding company is not authorized to write a bond here in Clayton County, they would have to partner up with a bonding company that is authorized to write bonds here.
Okay.
Okay. Any other questions, ma'am?
No, sir.
Okay, you're free to go back.
Your Honor, Ms. Peen bonded out before court. Next up is going to be Ms. Reeves.
Okay, thank you. Ms. Reeves, ma'am, you're charged with 1 count of trafficking marijuana. Now, you're in the boat where I cannot set bond for this offense. And I think this is your first arrest, at least from what I saw from your criminal history. anything over 10 pounds, trafficking marijuana, judge can't set bond at the initial hearing. There's going to be some additional information I'll give to you in a moment, but your preliminary hearing date is going to be set for October 27th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. All right, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. The additional information that I was going to tell you is that you would have to speak to your lawyer. The lawyer would have to speak to the district attorney's office. This being your first arrest, they may consent to a bond for you before the date that I gave you. The preliminary hearing is October 27th. The bond hearing is going to be set for October 29th, and they're both at 8:30 in the morning, courtroom 201. So speak to your lawyer about contacting the district attorney's office and see if they'll consent to a bond for you. Okay? Do you have any questions of me? Okay, ma'am, you're free to go back.
Next is Miss Steele, Your Honor. She's in the wheelchair right here.
Okay. Ma'am, you're charged with one count of simple battery. Bond is going to be set at $4,000. Do you believe you can post that bond?
Yeah,
I thought I heard no, then yes.
no, yes, I just have a question.
Okay, we'll get to your question in a second. There's going to be a stay away provision on this bond to stay away from a Shelton Bolden. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Now, do you want me to see if you qualify for the appointment of a lawyer? I'm sorry, ma'am.
Yes.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, what was your question?
I'm sorry, just over.
No, just take a moment, take a breath.
This is my son. I can't be around my son until what?
So the short answer is, as of now, you're classified as the offender and he's classified as the victim. He can choose to do what he wants to do. Like, I'm not afraid of her. It's okay. That condition can be lifted.
He's only 9 years old.
And were you the caregiver?
Yes.
Where is he now?
He's at home with his stepdad.
Okay. So, ma'am, all right, give me a second. Hold on. I got to look at one more thing. While I'm looking, are you aware that there most likely will be a defects case opened up because of this incident?
No, I wasn't aware of it. No. This is crazy.
Okay. I was just looking back at your criminal history. I'm going to remove this stay away provision. I don't know what the Department of Family and Children Services is going to do on the case, but there most likely will be a case opened up. And because of what has happened in the state of Georgia, of children dying at the hands of their parents, there could be a situation where they remove the child from the home. So you just need to be aware of that. And I tell people all the time, man, you're in control of what you do with your hands. You're in control of what you do with your body. And there are a lot of people on my calendar every day: battery, criminal trespass, simple battery, simple assault, because they just believe they can do whatever they want to do to another person. So I'm going to remove the condition and I'll see what happens with defects. Do you have any other questions for me?
No.
Okay, ma'am, you're free to go back. Okay, Ms. Walton, you're charged with 1 count of driving under influence of alcohol to the extent that you're a less safe driver, 3 counts of endangerment of a child by driving under the influence, 1 count of improper backing, and 3 counts of not having a child properly restrained. I've set bond on all of these offenses. There's going to be a $5,000 bond on the driving under the influence charge. For the child endangerment, driving under influence, there's going to be a $2,000 bond set for each count. For the improper backing, there's going to be a $500 bond. And for the 3 counts of child restraint violation, there's going to be a $500 bond set for each. So your total bond is going to be, let's see, looks like $13,000. Do you believe you can post that bond, ma'am?
Yes,
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes,
Okay. How much do you make per hour or per month?
Did you say, I'm sorry, my mind went blank.
How much did you make per hour or per month?
$12 an hour.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, I wanted to know, how to put this. If I wasn't in the car and I pulled over for safety, I'm not from this county.
Okay.
I pulled over for safety and me and the kids were sitting across the street from where I pulled over for safety because I was trying to get charged for my phone. And someone must have called the police about my car being on the side and by the media. I was just trying to understand how I was being charged with child endangerment and backing up when I wasn't even in the car, and DUI, only having one drink.
The child endangerment is, the full title is child endangerment by DUI. And so the allegation is that because the police believe that you were driving under the influence of alcohol at the time that the children were in the car, that you endangered them. So the reason we do this whole process as quickly as possible is we try to get people lawyers so that they can talk to the lawyers, so this whole thing can get worked out and there can be a determination of whether there's sufficient proof to move forward. Okay. Any other questions?
And just I can make bond today.
Yes, ma'am. So what happens is after this hearing is over, like you're the last person on the ladies' side. I'm gonna switch over to the male side. And then when I'm done, I have to unpack all of the paperwork, make sure that I've signed where I need to sign, dot my I's, cross my T's, and I send the paperwork back over to the sheriff's department and they start inputting the information so that it's in the system. So now the bonds that you have, you can at least, when you're able to use the phone, start calling around the bonding companies and trying to make arrangements for your bond so that when the paperwork gets back and the paperwork gets inputted, the bonding company is there waiting to get you out.
And that was 1,300 or 1,000?
Yes, ma'am.
1,300?
I'm sorry, 13,000. Okay. And so the percentage amount, I presume that's what you were saying with the 1,300. So that's around the number. Okay. Anything else, ma'am?
No, sir, thank you.
Okay, you're free to go back.
That's it, though, ladies, Your Honor.
Okay, thank you.
Thank you.
Are you Mr. Boswell?
Sir.
Sir, you're charged with one count of family violence battery. The bond is going to be set at $5,000. Do you believe you can post that bond? Uh-oh. He froze. Ouch. I'm sorry, did you hear me, Mr. Boswell?
No, sir, it just paused and came back on.
Okay, you're charged with one count of family violence battery. The bond is set at $5,000. Do you believe you can post that bond?
No, sir, I was going to ask her to be reduced.
So,
I'm not working right now.
Let them talk.
so I'll get to that conversation in a moment. Okay. There's going to be a stay away provision on the bond to stay away from a Fatima Gatson. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of lawyer?
Yes, sir, please.
Okay, you do qualify, Mr. Boswell. I'm going to appoint a lawyer to represent you. Now, I'm going to take a look at your criminal history. I don't, if you've noticed, I've set all of the bonds for battery at 5,000, all the bonds for simple battery at $4,000. And one of the concerns that I have with these battery cases is that you're an adult and you should know how to keep your hands to yourself. And allegation in this particular case is that you punched a person, Miss Gasson, on the right side of her face with a closed fist, leaving visible bruising. So that's the allegation. So when you're asking me to reduce that bond, I'm generally not inclined. But is there something that you believe I should consider?
Yes, sir. God, please.
Yes.
Yes, sir. All right. I was gonna say me and Fatima Gatson, that's been my girl for like about a year. We've been in a relationship and stuff. She was in a heated moment at the moment, and she had called them and said that I heard her, but I know for a fact I didn't, and I was there when this happened, and I was able to look at her face and everything. There was no evidence of anything. We talked about this, and as they got to the bottom of it, we tried to call the courts and everything. We called the car he gave us, Clayton County Court. They said, you couldn't find out a warrant unless I would come up here and then, pretty much like turn in myself. But I know I didn't do anything, so I didn't think it was no cause for that. But a few days, like we was trying to find and end the case because we had got down to the bottom of it. No, that I didn't hear her. She was in a hype moment at the moment. So we got down to the bottom of it, and then they were saying the only way we could say the case is, done is get in touch with the police officer, but he did not put his number on the card, only the case number. So we couldn't get in touch with anyone. So a few days later, the police just show up while I'm in her bed. Like I wouldn't be laying in her bed if I hit a woman. And I don't hit women, so I've been all my life.
So hold on. Let me stop you right there, because I've had cases as a judge where a person had warrants written out for 3 or 4 years, where he and his girlfriend would get in fights and get back together, get in fights, get back together, get in fights, get back together. Once you call the police, you take it out of your hands. You place it in a third party's hand to decide what to do about your life. So to the extent that you're telling me that your girlfriend or friend, girl, called the police and lied on you and had you arrested, you need to leave her alone. You need to stay away from her. You need to not go back around her, because this is going to happen again and again and again. So the short answer is I'm not going to reduce it. And if she wants the solicitor's office to drop the charges, she can call the solicitor's office to drop the charges. But I'm going to let you know, Mr. Boswell, the thing I always tell people, the first way to drop the charges is not to call the police in the first instance. Okay? Because now it's the state of Georgia versus Mr. Boswell. It's not Miss Gaston. And she can say, do whatever she want to say and do. But it's going to be the solicitor's office that decides how far this case goes. Okay. Let me see. Did I appoint you a lawyer? Yes, I did. Is there anything else, Mr. Boswell?
Yes, sir. One more thing. Where Fatima Gasson stays is in a hotel, and I saying my mom stays like 2 doors down from her, so I want to be able to go visit my mom. And even when my mom's just in there, like she's like part of the family, like she comes over there herself. But
so the stay away provision is to stay away from Miss Gaston. You can go to your mom's house. If you see Miss Gasson, you probably should turn and walk the other way. Okay. Anything else, sir?
No, sir.
All right, you're free to go back.
Wow.
Mr. Brown, sir, you're charged with 1 count of driving on a suspended license, 1 count of an improper lane change, and 1 count of driving on the wrong side of the road. There's going to be a bond set at $1,500 for the improper lane change. I'm sorry, for driving on a suspended license. There's going to be a $500 bond set for the improper lane change, and a $500 bond set for driving on the wrong side of the road. So that's going to be a total bond of $2,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That case, or that date will get moved upon your bonding out, and you'll get a new date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Let's see. Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. So my total of my bond would be like almost $300 because it's 2,500. So it's like 10% there, right? So bond the company.
Yes, sir. It'll be roughly that amount.
300. All right. Thank you.
You're welcome.
Call.
Are you Ramon Collier?
Yes.
Okay. Sir, you're charged 1 count of driving on a suspended license, 1 count of speeding. Do you know if your bond has already been set?
Yes.
Okay. So the amount, these are set by schedule, and I didn't get a pre-printed bond order. So I believe that you were already, as we would call OTB, which is out to bond. Did you fill out? You did. No, you didn't. So, Mr. Collier, you're supposed to be going through the bonding process right now instead of being here. But since you're here, it looks like with the driving on a suspended license, the schedule is 1,500, and the speeding, it could be anywhere from 500 to 1,000 based upon whether they consider you to be a super speeder or not. Would you like for me to consider whether you qualify for a lawyer?
Yes, and am I qualified for a bond with those?
Give me 1 second. First question, do you currently work?
No.
Okay, so you qualify for the appointment of a lawyer. If your bond has already been set, number one, I can't reduce it. But these bonds are set by schedule, which means these are offenses where judges decided certain offenses, we're just going to preset the bond so the person doesn't have to come before a judge. And person can just make the arrangements and bond out. So I don't reduce those because they were set by people that sat down and thought about what the appropriate bond should be. Okay. Do you have any other questions for me? Okay, so I'm going to appoint a lawyer to represent you, all right?
All right.
Okay, you're free to go back, Mr. Collier.
Honor.
Mr. Connor, sir, you're charged 1 count of driving on a suspended license, 1 count of driving a vehicle with no insurance, and 1 count of having a defective headlight. Bond is going to be set at $1,500 for the driving on a suspended license, $1,000 for driving without insurance, and $500 for the defective headlight. So that's going to be a total bond of $3,000. Do you believe you can post that bond, sir? Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, Mr. Connor. Going to, I'm sorry, sir.
I'm on it, 3,000?
Yes, sir. These are all set by schedule also. So if you have gotten the information from the jail, is probably higher than what I said, but that's because the Sheriff's Department is required to add fees to any bond that's set. Okay, anything else?
No, that's it.
Okay, sir, you're free to go back.
Davis.
Good afternoon, Your Honor. Thank you for your time.
Good afternoon, Mr. Davis. You're charged with 1 count of family violence battery. Bond is going to be set at $5,000. Do you believe you can post that bond?
No, Your Honor.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Absolutely, Your Honor.
Okay, you do qualify, Mr. Davis. I'm going to appoint a lawyer to represent you. There's going to be a stay away provision on this bond to stay away from a Tamar Davis. Do you understand that?
I understand, Your Honor.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. Now, Mr. Davis, I would encourage you to contact the bonding companies that are authorized to write bonds, because their only business model is helping people to get out of jail. And so you may be surprised at the arrangements that they will be willing to make with you to help you get out.
I understand, Your Honor. If I may.
Yes, sir.
And I have been listening. I am requesting, if I may, a bond reduction, as well as the changing of the stay away order to a no violence contact. I'm requesting that under a hardship. My wife has a disability, which makes her not have the ability to care for our 5-year-old daughter. In addition to the fact that I am the one who takes my wife, I care for my wife as well, taking her to and from work every day. Without her going to work, our family suffers. The distance from her job costs almost $100 each way to take an Uber, which is 3 times as much as she'd make in the entire day. I do understand the magnitude of the situation, and respectfully, I apologize for us being here under these circumstances, but I am requesting those things, if I may. I have no criminal background, Your Honor. And I really just want to get back to my family and help them.
Give me a second, Mr. Davis. I've heard what you said. I'm considering it. I'm looking at some things.
If I may, I also like to add, Your Honor, that I just not too recently migrated from Philadelphia, Pennsylvania, and we don't really have any other support in the state of Georgia.
Okay, from looking at this, Mr. Davis, this appears to be your first arrest. I will reduce this to $3,000, but I am not going to change the stay away provision on the bond.
I understand, Your Honor, but I thank you for concern. And thank you for the reduction as well.
Mr.
Oh, no,
Davis,
I'm sorry, Your Honor. One other thing, and if maybe you can just give me direction, because the other part of that is, I'm a subcontractor, and basically all of my tools are kept at home at this location where my wife resides. In a stay away order, I don't know how to maneuver in terms of trying to be.
you can make arrangements with the sheriff's department when you're bonding out, where they will meet you at the location, at the residence, and they will stay there for a brief period of time for you to remove items that you need to go about your daily living. The only reason I'm reducing this, Mr. Davis, is because from looking at your criminal history, this is your first arrest. But the allegations are serious. And I've said this to others, and I say it all the time, because battery, these cases come up more than people would believe. You have control over what you do with your hands. I hope the allegations are not true, but you know, as an adult, you shouldn't be before me.
I understand.
Okay.
Yeah.
All right, sir. You're free to go back.
Thank you, Your Honor.
Great.
Mr. Green, sir, you're charged with 1 count of violation of Georgia Controlled Substance Act, 1 count of possession of marijuana with the intent to sell, 1 count of an open container violation, 1 count of driving license that has expired, and 1 count of drug-related objects. So there's going to be a $5,000 bond on the possession of marijuana more than an ounce. Charge a $10,000 bond on the possession of marijuana with the intent to sell, a $500 bond on the open container violation, a $500 bond on driving on an expired license, and a $1,500 bond on the possession or use of drug-related objects. So you're going to have a total bond set at $17,500. Do you believe you can post that bond?
Yes, sir. If it's possible, may I ask for a reduction?
No. I mean, you can ask, but I'm not going to do it. If you are in the possession as allegation of drugs that are packaged or prepackaged in the sense of being sold, that doesn't mean you have to stay in bond. But if you're going to run a business, you need to be able and be prepared, especially if that business is an illegal business, to pay for bond. Okay.
Yes, sir.
Your preliminary hearing date is going to be set for August 27th at 8:30 in the morning. Court 1. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, sir, you're free to go back.
Oh.
Mr. Hall, sir, you're charged with 1 count of battery, family violence. I've set the bond at $5,000. You believe you can post that bond?
Sir.
There's going to be a stay away provision on the bond to stay away from a Decoria Reed. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Hold on, this is the office calling. Give me 1 second.
Yes, sir.
Okay, Mr. Hall, I'm back. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Sir.
Okay, Mr. Hall, you're free to go back.
Go ahead, sir.
What's your last name, sir?
It's pronounced Georgia.
Okay, Mr. Jarju, sir, you're charged with 1 count of loitering or prowling and 1 count of possession of marijuana less than an ounce. These are both misdemeanor offenses. The bond is going to be set at $1,000 on the loitering or prowling charge and $1,500 on the possession of marijuana less than an ounce. So your total bond is going to be set at $2,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning in courtroom 201. That date will get waived. Excuse me, upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, Mr. Jarju?
No, sir. I don't think that would be necessary. So thank you.
Okay. Do you have any questions of me?
Yes. 2, 1, can you repeat the total amount you gave me?
$2,500. And it's going to be a little bit higher again because I don't have access to the fee schedule that the sheriff's department has to add onto every bond.
Do you know generally how much it is? You can estimate.
It may be close to $3,000. I don't. It's sincerely a mystery to me, and I'm just repeating based upon information that I've heard from people that are in your position, because both of these are set by schedule, which means you may have already been given a total bond number.
Yeah, that's why I asked, because they already gave me a total when I was getting booked in. So, because you gave me a total that was less than that, so I just wanted to make sure.
My amount is the amount minus the fees.
Okay, so this is probably the one with the fees then.
Yes, the sheriff's department, they're required to do it by law. They have the fee schedule, and I just don't have time to be sitting with a calculator with all of the people that I have to see.
Understand.
Okay, anything else, sir?
Yeah, because about I wanted to ask about the loitering charge, because honestly, that's the first time I've really gotten one. So I just would like some more background on That's a question for your attorney, sir.
Hold on 1 second, Mr. Georgiou. Okay, so the basis of the charge is that, from what I've read, is that you were sitting in your car at an apartment complex where you didn't live.
Correct. I was, I live in the area, so I guess that's what they explained to me as well.
So this is something that your lawyer may be able to work through. And honestly, I don't know, because it's going to be based upon the testimony of the officers that were there that arrested you, because there's a reason that they came to you, and that reason is either going to be something valid or not valid, but that's where your lawyer comes in.
Okay, so can I be appointed to a lawyer then? Because I would like to.
Okay. Let's see. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions? Other questions?
No, I think that's.
Okay, sir. You're free to go back.
Go.
Mr. Jones, sir, you're charged with one count of driving a vehicle with no license, one count of possession of marijuana less than an ounce, and one count of possession of drug-related objects. All of these are misdemeanor offenses. There's going to be 1,000.
I'm sorry, Your Honor. We lost connection. I apologize. I'm about to repeat your thing.
Okay. So I'll start over, Mr. Jones. You're charged with one count of driving a vehicle with no license. Bond is going to be set at $1,000 on that. One count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And one count of possession of drug-related objects. Bond is going to also be set at $1,500. So you're going to have a total bond set at $4,000. These are all misdemeanor offenses. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning in courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. And also have a question.
Okay, we'll get to it. Give me a second. I promise I'm not going to cut you off. Okay, Mr. Jones.
Yes, sir.
You're on the line, but I'm gonna appoint a lawyer to you anyway. Now I cut you off. What was your question?
Okay, recently, not so long ago, the mother of my children, my two daughters, put out a missing report, and she was in another state with me saying that, therefore she's not in my home anymore, and I'm taking care of both of my daughters alone. So I was asking, can I get a reduction, because it's been hard paying bills and doing everything I'm doing for me and my daughters.
No, I'm not gonna reduce it, Mr. Jones. The no license and the possession of marijuana less than an ounce, they're set by schedule. Like I said before, judges sat down and determined what bond was reasonable. The drug-related objects charge, that is also a charge that can be set by schedule. It wasn't set by schedule in your case, but that amount is also $1,500. So I'm gonna leave it the way that it is.
All right, I appreciate it.
Okay. All right, so you're free to go back.
All right, thank you.
Mr. Murphy, you're charged with one count of failing to register. This is a felony offense. The bond is going to be set at $10,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for October 27th at 8:30 in the morning in courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Or
All right, good
Mr.
afternoon.
Or good afternoon, sir. You're charged with 1 count of cruelty to children, 2nd degree. This is a felony offense. Bond is going to be set at $10,000. You believe you can post this bond?
It's a high possibility, yes, Your Honor.
Okay. There's going to be a preliminary hearing date set for October 27th at 8:30 in the morning in courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I've set a stay away provision on the bond, but it's something that I would like to have a discussion with you about.
Me as well, Your Honor.
So this involves a young child, and I'm gonna lift that stay away provision.
Thank you
Are
so
you
much.
requesting me to lift it?
No, but I totally agree, Your Honor. I totally agree.
Okay, I'm going to lift it because this seems to be an accidental situation. I don't have all of the information available to me, but
But you are correct. You are correct, Your Honor.
okay, I'm concerned enough not to interfere with anything that you may have to do to assist with your family. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor, and I would also like to ask the courts to consider a small reduction in order for me to be able to help my child get further in his rehabilitation because I'm a father of 10. He needs me, Your Honor. My wife needs me. This has been strenuous on all of us. I'm not even sure if my wife could even mentally handle this whole situation. It's just been a very traumatic situation for all of us. And by me being gone, Your Honor, it's making my family crumble, literally.
Okay. Give me a second. I'm looking something up. Mr. Ward, it seems like you're a multi-state offender with cases out of Des Moines and Seattle.
Yeah, that's the same state.
So there's a city called Des Moines in Washington State.
Yes, sir. Yes, Your Honor.
Okay. Okay, so I'm not unsympathetic to your situation. I'm going to reduce this down to $5,000. But what is showing on here is that you have 2 warrants for your arrest. One out of Seattle, Washington, and one out of Jonesboro, Georgia. So if you post bond, you're probably not going to get released.
Yeah, I've been trying to get that Seattle, Washington warrant resolved. And I guess the end result was they just said that in order to get it squared away, I had to return to the state, which
Right.
I'm not really willing to do because we reside here. I've been a resident here for the last 8 years. So that's just not even an option for me and my family.
Well, you may be in a situation where they issue a fugitive from justice warrant. If that's the case, the Clayton County Sheriff's Department be required to hold you.
No,
And that was out of 2015. Okay, Mr. Orr. I am or have appointed a lawyer to represent you. Do you have any questions for me?
Yes, Your Honor, just one. Can you repeat the nature of the name of the crime that I'm being?
Cruelty to children in the 2nd degree is a crime in the state of Georgia that is a felony. And all it basically states is that you did an act that caused a child to suffer pain. There's no intent requirement involved in that. So you don't have to intend to cause the child pain. You just have to intend to do the act that caused the pain.
Okay, Your Honor.
Okay.
Thank you so much.
All right, sir, you're free to go back.
Read. Yes.
Okay, you are Mr. Reed, R-E-I-D?
Yes.
Okay, sir, you're charged with 1 count of criminal trespass. I've set the bond at $2,000.
Oh, sorry.
Hey, yo, stop. Don't do that.
So, Mr. Reed, all I'm here is to tell you what you're charged with, give you a bond, give you hearing dates, and see if you want a lawyer, okay? All right. Are you okay, sir? You're charged with criminal trespass. I've set the bond at $2,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Are you currently working, sir?
Yes, I am.
How much do you make per hour?
What?
How much do you make per hour?
Oh, 200 to 300.
Okay. I'm going to find that you qualify, sir. Going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, so you're free to go back.
Thank you, sir. What, thank you. What's the? Yes, sir. Thank you.
And Mr. Raymond, you wanted me to do a continuance for him, correct?
That's correct. Yes, yes, sir.
Okay, Mr. Schaefer.
You step up, Mr. Schaefer.
Mr. Schaefer, sir, you're charged with 1 count of family violence battery. The bond is going to be set at $5,000. Do you believe you can post that bond?
Sir.
Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Looks like you didn't fill out your court-appointed form. Are you going to represent yourself?
No, sir, I did fill it out to the best of my ability.
You said you did?
Yes, I did to the best of my ability.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
No, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Due to the fact that I'm no longer in contact with the victim, and I'm not familiar with her, like where she reside or where she work or anything. I was wondering, can you reduce the bail for me a little bit so that I can make bail?
So these events allegedly occurred over a year ago, August 21st.
Right, I haven't seen the person since.
Well, the bond, the warrants were issued that day.
Without my knowledge.
I'm sorry, sir.
That was done without my knowledge. I had no knowledge of what was being issued for me. And I never seen the person again, even after that night that it came.
Okay, I'm looking at your criminal history. Give me a second. I'm going to leave it where it is. It says you have 18 cycles, which those are encounters with the police. You got an aggravated assault out of 2017, aggravated battery. So I'm going to leave it where it is, Mr. Schaefer. Is there anything else, sir?
No, sir.
Okay, you're free to go back.
Sure. You want that?
Sir, you're charged with one count of misdemeanor theft by shoplifting and one count of possession of drug-related objects. There's going to be a $2,000 bond set on the shoplifting charge and a $1,500 bond set on the drug-related objects charge. So that's a total bond of $3,500. Do you believe you can post that bond?
I have no idea.
Okay. Would you like for me to see if you qualify for the appointment, excuse me, of a lawyer?
Yes, Your Honor.
Okay. Okay, Mr. Schaefer, you do qualify. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Do you have any questions of me?
I feel like the shoplifting. I feel like that charge right there is bogus. I was not attempting to shoplift. The equipment was acting faulty, and when they came in and asked me to move to another machine, I did. I was scanning my items. Upon leaving the store, sir, I felt like something was wrong. Looking at my receipts, I did not leave the property and not left even the second set of doors to the property. When I was like, something's wrong. And I was grabbed by the security or whatever. I was not attempting to shoplift. I didn't go into the store with any thoughts of shoplifting.
none of that. And when I was, like I said, as I noticed that something was wrong, that's when they grabbed me and said, "You need to come with me."
Mr. Sherrod, this was at a Walmart, correct?
Yes, sir.
So you need to make sure that your lawyer subpoenas the video. Walmart has video cameras every 10 or 15 feet. So everything that you just told me would have been captured on video. Tell your lawyer what you just told me. Lawyer needs to get the video, and then you guys can see what you can do with that. Okay.
Okay.
All right, sir.
Also,
Anything else?
Okay. No, that's it.
Okay, you're free to go back.
Come on, Walker.
Good afternoon, Judge. Yes.
Good afternoon, Mr. Walker. You're charged with 1 count of driving a vehicle on a suspended license and 1 count of allegedly concealing the identification of a vehicle. There's going to be a $1,500 bond set on the driving on suspended license charge and a $500 bond set on the concealing the ID of motor vehicle. So that's going to be a $2,000 bond. Do you believe you can post that bond, sir?
No, sir, but when we bought the car, it already had the tag on there. That's what I was trying to explain to the officer, that tag was already on the car. And now, we got the tag corrected for the car that we own now. But that was the tag that came on that car at that time.
Mr. Walker, would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, I do. Is there any way that you can lower the bond just a little bit?
Okay,
Oh,
these bonds are both set by schedule, so I'm not gonna lower it. You do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be October 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. Now you need to tell your lawyer the things that you told me, and your lawyer may be able to assist you, okay?
As I said, 2,500.
$2,000.
Okay, thank you.
Okay, sir, you're free to go back.
Hello, sir.
Mr. Williams, hello, sir. You're charged with 1 count of battery. Bond is going to be set at $5,000. Do you believe you can post that bond? Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. Is there a chance for a signature bar?
Give me 1 second. You do qualify for the appointment of a lawyer. Going to appoint a lawyer to represent you. So the process of getting a signature bond is I have to continue your case over so that I could speak with the chief judge. She makes the determinations on who gets signature bonds or not. The allegation in this case is that you punched Miss Raines twice in the face. I do not believe she would be inclined to grant you a signature bond based upon those allegations. Okay.
Yes, sir.
And it looks like your criminal history. You have a warrant for your arrest out of Alpharetta. Did you know that?
Alpharetta, what is Alpharetta? I haven't been in Alpharetta. Never been.
Failure to appear. The warrant was issued on August 17th of this year.
No, sir. Never been in Alpharetta. Never been in Alpharetta.
Okay. So
I was that's not my case, but I was arrested for it, and they sent me to the hospital on Riverdale Road, the South Regional. But I've never been in Alpharetta. never been in that.
Okay, and it says you were arrested on March 21st of this year for battery in a public transit vehicle or station and robbery by sudden snatching. So hold on. I'm just telling you that to tell you you're not gonna get an OR bond.
Complete wrong person. I can tell you the honest truth. Complete wrong person. My hand on the Bible, and I'm telling you the honest truth. I never did. I have no car. I'm homeless. I stayed in Jonesboro, not Jonesboro Road, but yeah, Jonesboro Road. I have no clue of what that is. No clue what it is. The honest truth. I know nothing else.
So are the last 4 digits of your social security number 0444?
9344. Jesse Williams is my real name. They arrested me for Jason Williams the day I was telling you about. They sent me to the hospital. I have schizophrenia. That's about it. Other than that, I have no clue of what that charge is.
Okay, well, I can tell you you're not gonna get an OR bond. And in this case, there's gonna be a stay away provision on the bond, stay away from a quarry range. Do you understand that?
So no signature bond.
He said, no, sir. You don't cut him up while he's talking. Let him finish talking. If you have a question, if you want to ask him a question, they'll ask you, okay?
I'm
You
trying to
already
make sure
said
I
no,
don't
you
get
already
charged
said
for
no
the
the first time.
charge. I have no clue. That's
You see that same questions over and over.
Understood.
He told you no already.
So, Mr. Williams, where were you born? What state?
what state I was born.
Yes.
Atlanta, Georgia.
I'm sorry, sir.
Atlanta, Georgia. Jesse Williams is my main name.
Okay. Well, I don't know if someone has cloned your identification, your information, but there's a hyphenation on the name. And one of the things that happens, Mr. Williams, is that's why they run your fingerprints so that they can try to match people together and not just by a name. But there's a lot of identifying information that matches up with you and this. So I've appointed you a lawyer. Is there anything else that you want from me?
I want you to know my real name, Jesse Williams.
Okay.
Jesse, J-S-S-I-E, not Jason.
Okay.
Jason Robert is not my name.
You step down. You step off.
Thank you. Have a good one.
You too. So do we have Mr. Carter?
Carter?
Yes.
Let me see that list. I don't remember seeing a Carter.
He's the last person as an add-on. He was on yesterday's list and it was written as a juvenile. I sent an email over to the DJJ and they said that he was brought over here because he's now 17. He was 16 at the time that this was committed. His LE number is 219-7985.
219-79. Yeah, we don't have him on this list. Nobody told us anything about the add-on.
Okay, can we do him? And I apologize because I know today has been a long time, but I don't want to leave him over for the weekend.
All right, no problem.
So I'll just stand by until you can get him, and then he's not getting bonded. It'll be a pretty quick situation.
Okay.
All right, thank you.
Your Honor, we have
Okay, give me 1 second. I'm printing out a bond order form. Mr. Carter, sir, you were here on a warrant that was issued back in July of this year. And the first charge is armed robbery. Bond is going to be denied on that charge. I can't set bond on an armed robbery charge at first appearance. The second count is hijacking a motor vehicle. Bond is going to be denied on that charge also. And the third charge is aggravated assault with intent to rob. And bond is going to be denied on that charge. This is, I'll give you the abbreviated scenario. And when I'm done talking, I'll give you the opportunity to ask whatever questions that you may want to ask. You're going to have a preliminary hearing date set for October 27th at 8:30 in the morning in courtroom 201. I can appoint a lawyer for you if you want me to appoint a lawyer, or do you already have a lawyer? I'm sorry, buffered a little bit. Did you?
Say it again. You can appoint one for me.
Okay, I'm going to appoint a lawyer to represent you, Mr. Carter. I'm going to set a bond hearing date for October 29th at 8:30 in the morning. Now, during this and all other proceedings, you're going to have following rights. And I'm going to tell you the rights that you have. You have the right to the presumption of innocence. You have the right to indictment by a grand jury. You have the right to a speedy and public trial by jury. You have the right to see, hear, and question witnesses who are called to testify against you. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to testify on your own behalf or offer evidence in your own defense. And finally, you have the right to an attorney. And if you can't afford an attorney, one can be appointed to represent you, as I did here today. Now, you look like you may have had some questions. Do you have any questions for me, Mr. Carter?
What is the aggravated assault charge?
The allegation in the aggravated assault charge is that.
Where did it come from?
It says that you forced the alleged victim, Anastasia Cardona, to exit her vehicle and then proceeded to steal the vehicle with 3 other juveniles. And it says the vehicle was a red 2016 Nissan Versa. And the contents included ATM cards. And so that's the aggravated assault with intent to rob, because they're alleging that there was a firearm that was used. And whenever you point a firearm at a person, that is considered and could be, it was considered an aggravated assault under the statute in Georgia. So when they combine the two of saying you had a firearm and then there were ATM cards taken, that's aggravated assault with intent to rob.
So last time I went to court, they told me I was on trial with armed robbery and carjacking, but they said carjacking fall under armed robbery.
Yeah, and that's why we appoint lawyers at this early stage, is because the lawyer is the person that can pick apart the facts and the evidence. As you stand here today, you're an innocent person. The state of Georgia has to prove each and every allegation beyond a reasonable doubt. So you know what the shorthand that I would tell my clients is, that's what they say. Now we have to figure out what we're going to say. Okay. Anything else, Mr. Carter?
When would I be able to talk to my lawyer?
So I'm going to send the paperwork over today for the appointment of the lawyer. It's going to be the Clayton County Public Defender's Office. And because I don't work in that office, I don't know like when they will have it set up. In other offices, people come in on the weekends, people come in on, whatever day. So if you do not hear from anyone by Monday, you should have either you or your family members calling the Clayton County Public Defender's Office to let them know that you want to speak to a lawyer. Anything else, sir?
Okay.
Okay, Mr. Carter, you're free to go back. Thank you for getting Mr. Carter. Today was a wild day. I apologize for what steps that I may have taken to extend the day.
You okay, sir?
So I hope you all have a great weekend.
You too. Thank you.